personal effects which were seized from the complainant's house. Your Honor is yet to report statements from essential witnesses. Your Honor, the verification of the title in respect of the said property. Prior number investigations, Your Honor, leading to the arrest of the accomplices, Your Honor. Your Honor, we are praying that the application be allowed as free before charges are preferred.
El Clasica case of Michael Rotich versus Republic. Sorry, Your Honor. Your Honor, the case of Michael Rotich versus Republic, 2016 EKR. Your Honor, at page 5, this is what Honorable Justice Luka Kimaru said, as he then was, that the trend where a person is arrested and are continued to hold that person without any charge or holding charge being preferred against that person is unconstitutional. Your Honor, it is page 5, the last paragraph of page 5 of that ruling. It should be the fourth sentence, where the judge starts with the word being the sentence as stated earlier in the ruling. Your Honor, that is the case here. The respondent before you has been brought, no charge, no holding charge. They want to keep him for 14 days so that they can conduct investigations. As a binding decision, Your Honor, we submit that the court cannot aid the DPP to breach the law. Your Honor, the respondent before you is a licensed auctioneer. It's an officer of this court. I have seen the application where one of the reasons why they want to do it is because they want to conduct a search of the property which allegedly was demolished and conduct a verification and do evaluation of the property. You know, one would wonder, why would you keep someone in custody for the IO to go and conduct a search at the arraigned house to verify the title or conduct the evaluation of the property? Do you need someone in custody? The answer is no. Your Honor, we therefore pray that the respondent before you being an officer of this court, he is not a flight risk. Your Honor, this is wish to supply the court with a copy of his this year's Auctioneer's license. Your Honor, he is before you because he did what he was licensed to do as an auctioneer. Yes, parties are dissatisfied. The complainant in this case has done the proper thing. He has gone before the before the Land and Environment Court here, where he has sought orders to restrain the person who instructed our client to conduct the eviction. That's the proper thing to do. You know, the complainant is before the ELC court. He has applied this morning in ELC case number E36 of 2022. Therefore, Your Honor, this process that the respondent has been brought to face is unfounded, but we'll deal with that once they make a decision to charge. But as of now, Your Honor, there is no reason why the respondent should be kept in custody for the police to conduct the investigations. It's unlawful. The same decision was arrived at by Honorable Justice Professor Ngugi. She also referred to the case of Michael Rotich, determined by Honorable Justice Kimaru, which I have referred to, and found that that practice is unlawful. It is a violation of the right to freedom, especially where there's no holding charge that has been presented before court. And therefore, submit, Your Honor, that you decline that invitation for you to breach the law, admit the respondent to reasonable terms, and we propose the terms of 20,000 shillings. There's no charge before him. He undertakes to report to the IO and cooperate with the IO in the investigations so that they can make a decision on how to proceed.
Nick, it is a matter that has been adjudicated over, and especially in the case of Betty Jemtai Kimeiwa versus the Republic. It's a 2018 matter where the reasons for the continued detention of Betty Jemtai Kimeiwa versus the Republic, it is a 2018 matter that was decided by your brother, Judge Edward Mureithi, at Cabernet. The reasons that were preferred by the prosecutioners at that time, including the reason to record statements of relevant witnesses and so on and so forth, it is the same reasons that have been preferred by the prosecution in the instant case.